Today we will discuss some of the hot topics. We all know that we are very close to the cap, so we will keep our discussion mostly on the cap. But end of the panel, if you have any questions, even if it is not cap related, we'll be glad to answer. The first question is for Santosh. What is different from year 2020 and 21? Those years, people did multiple registration through your friend's company, related companies and all, and there were no issues. So what changed and what is this multiple registration? Can you explain that, please?
Good. So, multiple registrations means filing multiple cap registrations on behalf of the same employee by different companies. Okay. In 2022, USCIS has clearly indicated that you have to attest to the fact that whenever you're submitting a registration, it's for a legitimate job offer and that you're not working in collusion with another employer or a registrant or an agent to unfairly increase the chances of the beneficiary's petition getting selected in lottery. Okay? If USCIS finds out that somebody has done multiple registrations and that in order to unfairly increase the chance of somebody's petition getting picked up in lottery, then they might issue an intent to deny. They might deny the petition and also refer them to federal authorities. So I know they not clearly define what they really mean by referring them to federal authorities, but I assume that there could be some criminal penalties for doing that.
So if two companies are unrelated or even related companies, if they have overlapping filings, that's what USCIS is looking into. So USCIS has been issuing intent to denies where they specifically say that you file 150 registrations, out of which 30 the other XYZ company also filed, so which is multiple registration, which is fraud and misrepresentation. So the next question is for Bhanu. I'm sure you have seen a lot of NIDs and intent to revoke. How do you defend this multiple registration, or can you even defend it?
If it comes to NOIRs or NOIDs on multiple registrations, whether we can defend it or not, it's on a case-by-case basis. There is no blanket rule on that. We have to look into all the facts of the situations, why we received this NOID or NOIR, and if there are any imagined circumstances or a fictional circumstances of the USCIS assumes, I think we can question these NOIRs and NOIDs. But how we do that, we have to look into each and every case on case-by-case basis. But we have to understand this. As you said, I think you asked questions, Somireddy, Santosh, and I'm going to continue with this answer there.
Yes.
In 2021, the difference between 2021 and 23 fiscal year, that in 2021 and 22 fiscal years, they did not have an attestation in the bottom for the misrepresentation, saying that they're not doing any multiple registrations or they're not gaming any system and everything. In 2023 fiscal year, they introduced that. And the result of that is, the reason why it happened is because of the court cases. There were court cases happened and settlement happened between the USCIS and the court, and the USCIS said that they're going to do more precautions on people not gaming the system and everything. And based upon and pursuant to that settlement, they introduced this penalty of perjury clause in the statement for willful misrepresentation of fraud, saying that they may be subject to the criminal laws if they willfully misrepresent about the multiple registration to game the system for the lottery. And the purpose of that is to make sure that the more people will have an opportunity to get selected in the lottery rather than few people trying to take undue advantage of that. And I think the result of this NOIDs and NOIRs also is part of that. I think that's what they're looking into. I think they were forced to do these NOIDs and NOIRs to ensure that system is properly utilized by the people.
So I have a question for Gunjan. So we are seeing that an employee is filing through, or a beneficiary is filing through multiple companies. Even 10, 15, the students are saying this is the last chance, so they want to file through multiple companies. Is that legal? Or this restriction is only for the employers to file multiple registration, but the employees can't do that?
First of all, once again, I'd like to thank ITServe for giving me this platform to be here. I'm humbled by the experience of, being here with such, prominent peers. So thank you for that opportunity. Now, to answer your question, I think, is there any, liability, on the employee? See, the employee can have a bona fide intent in terms of increasing his odds of selection and can file through, multiple business entities. But as long as those employers, those petitioners don't collude with each other to, further that intent of the employee to increase their chances of selection, the liability is more on the employer than, on the employee, because the notes are being sent to the petitioners, to the employers. So, in terms of responsibility of the employee, as I said, they can have a bona fide intent to be, to get their registrations filed through multiple entities.
So, from what you said, my understanding is that employees can file through multiple companies. So, an employee can have an offer from an Apple and also from the Google, and which is completely legal.
That is correct.
Okay. So, next question is to Prashanthi. So, we already had a similar discussion at Austin chapter. So, the question is multiple registration always intentional? So, can it happen unintentionally also? If yes, can you give some examples where people do that without knowing?
Right. Absolutely. It's possible to have multiple registrations because companies often have, more than one email address, and they create separate accounts. And sometimes maybe there's a team sitting in India and there's a team sitting here in the US. And it happens very often, actually, that they register for the same person twice. And of course, both the registrations then get denied. So it's possible to have multiple registrations and then get a denial on that. But also, there's another aspect of this, a more practical aspect that I wanted to bring to your attention. So when they're saying colluding with another company, how is USCIS going to prove that there is a collusion? In some instances, it might be very easy to prove, like they have the same office address, right? Or maybe the company owners are husband and wife, or something like that. Then it, of course, becomes very easy to prove collusion. But otherwise, I feel in the several NOIRs and NOIDs that we got, there is some phishing going on. USCIS is phishing and putting information out there and saying, oh, ABCD have together filed 300 registrations, and I see about 50 registrations are common among all 4 companies. So I'm saying that there could be another reason for this. It may not be collusion, because from what I found out, the company that approached me didn't know the other 3 companies. So either it could be that USCIS is just putting information out there, which is incorrect, or it could be that all of them are using the same recruiter. A lot of these recruiters are based out of Hyderabad, based out of, these big cities, and they send you 100 resumes, right? And you're using the same recruiter. So it could be that you're filing a H1 and XYZ also is filing the same person's H1. And sometimes even the beneficiaries don't know, because the recruiter has the passport copy and is giving out the passport copy to you, and XYZ company is filing for John. So it's possible that collusion is not intentional as well in this scenario. So just because USCIS is saying something, it doesn't necessarily mean that it's true. So when you get a NOID or a NOIR, there's no need to panic. As long as you haven't colluded, there is, of course, a way of responding to it.
Yeah, and one instance what I see is there are employers who scrape the resumes from job portals like desiOPT.com and Indeed and all those things. While you are doing this, scraping these resumes from there, another employer is also doing the same thing. So there could be chances that both of you are filing overlapping H1. So that could be one defense, like using same recruiter or using the same job portal. Because USCIS is alleging fraud and misrepresentation. One of the requirements for to commit a fraud or misrepresentation is that there has to be knowledge and an intent. And when you can prove that, there was no knowledge or intent, you can still get away with the fraud and misrepresentation part, and also even the multiple registration. And we can still question, can USCIS come up with a attestation or something which is not backed by statute? Does the regulation or the statute stops employers from doing multiple registration? That's a question also that can be debated and looked into. I don't think that is supported by any regulation that USCIS is imposing and having employers not file multiple registration. Yeah. Correct, exactly. So whether they will take it to the next level and have criminal and all these prosecutions, I doubt it, but because they don't have the legal standard to do that. Now, having said that, there are a lot of people who got the H1 already approved, who are on student visas and changed their status to H1. And now USCIS reopened those, and because they already changed the status, now the USCIS is reopening and denying those H1s. So Santosh, my question is, what happens to their status?
Yes. Sorry, before getting to that question, I just want to give a piece of advice. So before you submit someone's registration, please make sure you issue an offer letter and they sign the document saying that they are accepting the offer. Okay? Because you don't want to be in a situation where an employee or somebody, like a registrant, comes back and sues you that, hey, you submitted my registration without my knowledge, and because of you, I lost my other opportunity. So I highly recommend that you issue them an offer letter and have them sign it saying that they are accepting the offer before you submit their registration. And Thomas, you got in a very good question. So if once a person's change of state, petition is approved, H1 petition is approved, along with change of status, their status will automatically change to H1-B as of October 1st, assuming that the petition was approved by them. So if the petition is revoked after October 1st, they will lose their H1-B status. Now they lost their H1-B status as well as their F1 status. So the F1 status cannot be reinstated. Yeah, same thing applies to H4s and L1s too. And also please make sure whenever you're submitting an application for a change of status, make sure they have the dependents' petitions are also submitted along with their petitions, or if not, try to submit them before October 1st so that they don't lose their status.
So the next topic is a very controversial topic. We all know that H1 is filed for the fiscal year. So the start date is October 1st. And you are filing it on April 1st. So, and that's 6 months prior. And after that, once it's approved, they have to go for a stamping, which could take another 6 months or 8 months. So the whole process is like a year. So would any of the client support, would anyone give a requirement, their confirmation that they need an employee which would come after 1 year? So, which is not, in practicality that doesn't happen. So the question here is, how would you file? All the staffing companies, this is the same requirement. They are not unable to get a client confirmation. So this question is for Prashanthi, because
I knew it. I knew you would ask me this.
We both had a difference of opinion. So I'll start with Prashanthi on this. So I'll ask you the straight question, do we need a client or even a project to file an H1-B?
Again, this is where Thomas and I agreed to disagree that night, and we had a lot of fun discussing it. But so I am a person who is very cautious by nature, and so therefore I advise my clients accordingly also. So if a client came and told me, Prashanthi, I want to file a skeleton petition, I want to see how it works, shall we do it? I'll say, go ahead, do it. If they say, I want to file 150 H1-B petitions, skeleton petitions, with nothing, no client letter, no I-120, nothing, then I would be cautious and say, look, I don't think it's a good idea. So it depends on what volume you're talking about, right? In general, I usually tell my clients to submit some kind of documentation to show that their employment is not speculative. Now, we were discussing about this with the ITServe, ITServe decision, whether they debunked the notion of speculative employment or it's still in place. And I was saying that, when I started my practice during the Y2K time, 96, 97, 98, we would file skeleton petitions, just the I-129 forms, right? And petitioner letters and degree copies, and they would all get approved. There was no notion, even for IT consulting companies, of speculative employment, right? So after that, of course, this whole notion of speculative employment started coming in. But there was always the notion of having a bona fide job offer. But of course, it's up to USCIS how they decide to enforce this and how they decide to interpret what is a bona fide job offer and what isn't. Right? For example, if you are a product development company or you're a law firm and you choose to hire a person, you don't submit any documents. We don't usually submit. We just submit the degree copies and at the most maybe a copy of the lease and maybe the website, and that's about it. Because they don't ask about whether it's a bona fide job offer or not in that context. So really, it's all about how to practically get a H1 approval in the easiest way possible, right? That's what we tell our clients. It's more a practice than it is the black letter of the law. So we usually advise our clients to submit something, some documentation, either a SOW or a contract or something. Now, I wanted to differentiate between two different things. They could be that you have 5 different clients and you have contracts with all those clients, so you have an ongoing requirements and business relationship with that client, and you're filing a H1. You don't have a job for Praveen, but you're most likely to get Praveen into one of those POs that you have, right? So that is not speculative employment, though you don't have a job exactly for him at that point of time when you're filing the registration or filing the H1, right? But on the other side, if you are filing a H1, you're an IT consulting company, you have no requirements at all, you have no clients, and you're filing a H1-B petition. It is speculative, and USCIS is going to say at some point after you file the 3rd case or 4th case or 5th case, they're going to ask you, what are they going to be doing? Same, I'll give you another example, sorry, just one quick point and then. Another example, when we talk about in-house project, right, and we give all this information. The reason we're getting RFEs is because they're asking about speculative employment. Otherwise, they wouldn't care, no matter what you submitted. And they should approve the H1 then. So just these few examples that I wanted to give.
Okay, I have I'll ask the same question to all of you because audience wants to know your perspective. So Gunjan, you have a different perspective on this. Do we need a client or even a project to file the CAP H1?
So, speaking specifically, in the context of the nature of the information technology consulting industry, I like to err on the side of caution, and I only like to provide that information to USCIS which is accurate, which is true, and it doesn't involve any element of misrepresentation. Specifically in the context of individuals who are outside the country, for whom you're applying for consular processing, and we know there is no end client in sight, right, for that particular individual. On the LCAs, on the I-129, we are mentioning the work location of the employer's headquarters, right? The presumption here being that when that individual comes to the United States for a specific period of time, which again we don't know, so for a certain period of time, they will be stationed at the employer's business premises. In the context of documentation to provide, if there is no in-house project at which, for which this individual is going to be working, I strongly recommend not to provide any documentation, any in-house documentation if that individual is not going to, actually work on, for that project. Similarly, if you don't know, where that individual will be positioned, which end client that individual will be working for, I don't, again, recommend to provide a bunch of contracts. Even if you have, as an employer, you have a relationship with different vendors, different end clients, I don't recommend putting in a bunch of, client contracts as a part of your petition, because that does, provide an element of speculation. You are giving either the USCIS or the US consulate a reason to speculate, is he going to be working, for one of those, end clients? So I make the petition straightforward and simple, and I say, just provide the, the basic position title, and make sure you provide a, a detailed, comprehensive, job description of what that individual is going to do, but not to unnecessarily add contracts or, in-house project details when you don't know what that individual, first of all, where he'll be working and on what project will he be working on. That's my take.
Yeah. So, last 2 years, since the ITServe cases, we are seeing that a lot of companies are filing this skeleton petition or petitions without any specific project, and they are getting approved, hundreds of petitions. And the consulates are stamping, and is it by fluke or they are just being lucky that they are getting all these approvals? The question is to Bhanu. Yeah.
It's not lucky. I think they're approving as per the law, as per the required regulations and as per the statute. And if it comes to, if that is the answer you want me to expect from me, that will be my answer for that. Simple and plain and simple. And if it comes to the previous question which you asked, which is very, very important one, I respectfully partly agree, partly disagree with my colleagues. And I tend to agree more with Thomas on this issue. The reason is, we have to understand what the black letter law says for the H1-B approvability or H1-B validity, okay? The requirement is having a US entity, employer, a requirement in a specialty occupation, in a pro for specialty occupation, and there exists a valid employer-employee relationship. It does not say that whether you are a consulting business or there is no differentiation whether you're a consulting business or the employees works directly for you or not. So USCIS used to adjudicate these cases very accurately until 2008. In 2008, when the economy has gone down, they basically smashed all the cases. And 2010, they suddenly came up with this Newfield memo, which is basically completely ultra-virus. And kudos to ITServe on litigating that and getting stricken off that memo and the itinerary memo and everything. It's very important to know the history when we explain or when we try to fight with these cases with the USCIS, when they try to come and force you to provide itinerary or any speculative documents like client agreements, client letters, and or everything like that. And recently, this stance was even affirmed by the Ninth Circuit case. Okay, the district court in Ninth Circuit stood very strongly against the USCIS, saying that USCIS cannot make a decisions based upon this speculative, imagined circumstances. Employers are not required to show any third-party agreements or a client letters or any such kind of relationship. What they have to show is valid employer-employee relationship. That is whether the employer has a right to hire, fire, supervise, pay, control, or otherwise control. Or otherwise control. That is what the employer is required to show. If the employer can document any one of these factors under the preponderance of the evidence standard by establishing the nature of the business, they should be okay with filing an H1-B petition without mentioning any client, without having any client or anything like that. The reason why that is, the court affirmed in the decision saying that legal benching is also allowed. As long as employer complies by paying the wages that have been offered to the H1-B worker, and if the H1-B worker is providing the same working conditions that are provided to the US workers, it is absolutely okay. You all have to understand that. And it is very important that we prepare the cases that way. I'm a very conservative attorney if it comes to what documents to be submitted, what documents not to be submitted. Even from 2010, even when the Newfield memo came, we were hitting on the table all the time saying that these documents are not required. You just can't go with the common law definition because the definition of employer-employership has been defined in the statute, not by regulations. when it was defined in the statute, there is no controversy, there is no vacuum, or there is no room for the interpretation for the USCIS to use common law definition over there. And this is where I think that's what ITServe has become very successful in this. That's why I would say this. Talk to your attorneys like us. I mean, if you're using us, we are very thankful for that. We are very humbled. And to be honest with you all, I didn't get a chance to thank you all personally. Today, wherever I am, whatever I am, it's because of the trust ITServe members kept on me and our team that we do a good job as an immigration lawyers. And I'm really, really thankful for that. We hope we continue providing the same services. We hope you all will use our services accordingly. And if any issue there, I'm always there, sir. I'm just one text message
Thank
away
you.
for all of you.
Thank you. So I want to know Santosh's opinion too. So when an employer is signing the I-129, he is signing on penalty of perjury saying that there is a bona fide job offer. And even the registration, there is an attestation that the job offer is bona fide. So, on the same topic here, whether we need a project or client letter, what's your opinion on that, considering these attestations that the employer is making on the form I-129?
Yeah. So I want to make a differentiation here. At the time of submitting the registration, as long as you have a legitimate job offer, when I say legitimate job offer, you don't need to actually have a bona fide. There is a small distinction between having a legitimate job offer and a bona fide job offer, right? So for the registration purposes, as long as you intend to hire that individual and you made them an offer, they accepted it, that's sufficient. And as long as you are capable of placing them, once their petition gets selected in lottery, that is sufficient to submit the registration. Whereas when it comes to submitting the petition, right? So at the time of submitting the petition, you need to show that you actually have the work available for him, right? So if for example, if it's an IT product development company or like law firm as my colleagues mentioned, right? So it's obvious that they have work available. Whereas if it's a small IT consulting firm, like especially like companies that only do body shopping, then you have to show something to show that like you actually have the work available. So this could be like maybe you have interviews lined up with the person and then you have an MSA with that client. Or since it's not required at this point of time, we have been submitting the petitions without any of this stuff, but people like, especially the 221G stage, right? So you might end up in a situation where the officer is going to ask you to provide these documentation. So when you're submitting this documentation, you need to make sure that the documentation actually existed before you file the petition, right? Because the bona fide job offer should have been in existence at the time of filing the petition, right? So I highly recommend like you actually at least have an MSA or something that is signed before the date you file the petition.
Thomas,
Thank you.
can I just add one more point which I forgot?
Sure. Keep
Another
it very short.
Another argument, and we love to argue, as you know, and play the devil's advocate. So I'm not disagreeing or agreeing with anyone. I'm just presenting a counter argument. So another reason I think that a vendor letter or especially in the IT consulting, we're only talking about the IT consulting scenario, where a vendor letter is useful is in the context of specialty occupation. Now we know specialty occupation is alive and kicking, and they want to know what the job duties actually are. It's not about the job title. Just because you say software engineer doesn't mean it's a specialty occupation. They want to look at the job duties. And in order to look at the job duties, they don't want the petitioner to tell you what the job duties are. If you're working at another work site, they want it from the horse's mouth. So another useful aspect of a vendor letter or necessary aspect may be that you're asking the vendor or the end client to put in what the job description is so that there's no question about whether the job is a specialty occupation or not. It's just another point.
All right, thank you, Jan. So we have to look at the statute and the history behind it and how all this changed, right? So before, there was 3 memos from 1991 which dealt with the non-speculative and the itinerary. And then 1993, they had one, and then they came up with the new file memo in 2010 and subsequently the itinerary and control memo in 2018. All these memos, what they discussing was that the employment cannot be non-speculative, and there has to be a specific job offer, and it cannot be speculative. But what happened with this ITServe case is that they invalidated all these memos and saying that the USCIS cannot differentiate between a US employer and being a staffing company, third-party placement, they cannot differentiate and they cannot ask for contracts or to prove that there is a specific employment, non-specific employment. That was not legally, they invalidated it. So what changed is that the job can be speculative now. So like once Prashanthi was saying, if you have multiple requirements and you are not showing it in-house, or right now we know that there are a lot of in-house or remote positions, and you have a lot of requirements coming in. Can you file an H1-B based on that? So my take is yes, you can do that. That is speculative because you don't know at the time of filing on April 1st, you don't know where this person is going to work, right? But you have a lot of requirements. You get a Java developer, or you get a 50 Java developer, you can place them because you have a lot of vendor contracts and there's a lot of requirements coming in. So it's speculative job that H1 you are filing, but does the rule prohibit you from filing a speculative employment? That was a change that happened with the ITServe case, and you can still file it if you have requirements. And the only requirement is the job offer has to be bona fide. So when you can show that there's a lot of requirement for this, and you can file even not specifying any single project. And I have seen some of the people that what they do is they put in a master service agreement, and they file with that. So the downside of that is the USCIS will verify with the client, which you are mentioning, the end client. And if they say that we don't need this person, we don't even know this beneficiary, that is going to be a misrepresentation because you are pinning down to one specific contract. So being speculative, you can file multiple one. Bonafide job, not a bona fide job offer. One example is, one company has 2 employees and they are having a small office where they can sit 2 or 5 people. If you file 200 registrations, is that job offer bona fide? Not obviously, because he doesn't need anyone. If there is a site visit tomorrow, how would he prove that he has enough need for all these, let's say 50 selected? How would he prove that? So bona fide job offer depends on your size of the company, your requirements, but having a specific contract or a project is not necessary. That's the one reason why people are getting all these approvals. And it's not because USCIS overlooked this or they're just approving. So from March 10, 2020, we are seeing a big shift after the ITServe decision. So that's what I want before I conclude that topic. But having said that, how USCIS handles this issue and how the consulate or the FDN has handled this situation is completely different. So, so this question is for Santosh. So consulates are still asking for the client letter, right? So when there is no client letter, how do you address that issue with the consulate?
Good. So all the clients, the consulates are asking for the client letters. It's not mandatory that you have to provide the client letters. So in case wherever you don't have a client letter, then we usually provide an MSA, or like if the person has already been working with that company for the client, then we also provide the MSA, the invoices, or anything to show that the person actually has been working for that client, and the client does not typically issue the client letters, and they have been approving these visas.
So, Bhanu, this question is for you. In this consulate 221Gs, right? Are you seeing any major shift in the last 1 month on the client letters or asking for a project? Do you see any difference in the consulates?
Not much, Thomas. I mean, still, I don't think they made any changes to the policy which they're following as of now with the client letters or any clients or anything, any of such document requirements. But what we have seen is they're approving more visas in the past 1 month or past few months, basically, few months, when we actually tell them why the client letters are not required, why the end client agreements are not required. And as I said many times, I think we are in our previous Austin meeting also, I said about this, my experience with the Consulate General of Hyderabad at that time. They did admit that it could be a policy error that they're asking for these documents because it is inconsistent with the USCIS policy and the regulations also, you know. So I'm very confident that next 5-6 months, I think it will be corrected. And also, I believe I think ITServe is filing a lawsuit on that. And many people are joining in the lawsuit also. I think we will see a very positive outcome. I think it will be at least for the commencement of the next fiscal year, that is 2024 fiscal year, that is of October 1, 2023.
To add to that, recently we had an experience with a few of the guys who went for stamping. Maybe it's a result of, there's a lot of lobbying work being done by ITServe also, and a lot of lawsuits filed on these 221Gs and asking for client letter, including our office as well. Many litigation, mandamus lawsuits. So on this speculative employment, so when people went for stamping, when the consulate asked, first question they ask, which client are you going to work for? So they said, I'm not sure. My employer has multiple clients. I would be working on one of those projects which they have, but at this point, I am not aware of which project I would be working. And surprisingly, the consulates are issuing visas for that, even despite the fact that they did not specify one specific client. So I feel that I think ITServe, through other lobbying efforts they are doing in different consulates there's a lot of shift happening even for H1s that were filed without a specific project, which is a good sign. Now, I want to ask this question to Gunjan. We are now, consulates are viewing this differently, right? So there are a lot of FDNS site visits also happening where the officers are asking for the details of the project, and they're asking a lot of questions like the list of employees from all the list of employees of the company, and also the contracts. They're asking not the specific contract, they're asking for the whole contract the company has, and also how the company spend their PPP loan and all. How do you address these issues?
So I think, if the FDNS is asking for information, you have to see, is it, within the scope of their, inquiry. A lot of times they will ask for documentation which is, outside the scope of their jurisdiction. We had one of our clients had a site visit, by the FDNS on site, where they requested for W-2s, 1099s, of all the employees for the past, 3-4 years. And I think as attorneys, we have to intervene and tell them that, this is outside their scope. We cannot give them, access to this information. So that is the point where, we intervene and we ask them, if they're looking for a specific, if they're questioning with respect to a specific employee, we will, advise them to, restrict their inquiry to that particular employee only. We don't allow our clients to provide them, all the information that they're asking for. That's where we intervene.
Thank you. We are running short of time, so we'll keep the answers brief and we'll try to wrap it up. So Prashanthi, I have a question. So can the employer still file with level 1 wages? What's your opinion on that?
I don't see why not. It depends on every individual case. There is a certain way that you calculate the levels, right? Level 1, level 2, level 3, level 4. So as long as your case or the job is coming within that calculation, there's no reason why you can't do level 1. For example, if he has a bachelor's degree and is a fresh graduate, that will most probably be level 1. And we were getting RFEs, like all of us were getting RFEs, right, at some point of time, but I'm not seeing any RFEs for level 1 issues anymore. So the answer is yes.
Okay. So I want to ask one additional question onto that. can the employees still use the SOC code of computer programmer, a programmer analyst? Because we know the wages have gone up for software developers and all. So can they still use programmer analyst?
Yes, because something magical happened with the SOC codes and program analyst, systems analyst. I don't know how many of you actually noticed, but the job description itself changed. And for example, for systems analyst, they put in the job description itself, design complex programs, blah, blah, blah. So they put in the language that you usually put in if a job is a specialty occupation. So that gives me a lot of hope, and we have filed a lot of program analyst, systems analyst cases after the new SOC codes came out, and they were all approved. So I'm very hopeful about going back to filing systems analyst cases.
So this question is for Bhanu. Do we need an office space to file an H1? Does the employer need an office space? Can they have the office residential from home?
Answer is yes and no. Yes is if it's a IT consulting services company where employees predominantly work remotely, either at the third-party client side or from their home, then it can be a home-based business. We have done hundreds and hundreds of companies. We represented hundreds and hundreds of companies who have a home-based business, and they're completely and purely involved in third-party consulting services business. Under those circumstances, it's absolutely okay as long as you have a space for maintaining public access files and having a fixed times or certain times to allow public to view those public access files. Otherwise, it's always advisable to have a commercial office space.
To add to that, can we have multiple companies run from the same address? Would that impact the H1-B filing?
Answer is yes and no. Yes is if they have an identified space for that particular company in that sharing space, then it's absolutely okay. For example, we have a suite A in some building, and that suite is around 2,000 square feet. If the company X is using 1,000 square feet and company Y is using remaining 1,000 square feet, and if they can identify those two spaces as two different spaces, there is no problem at all. We have done several cases. We have represented hundreds of, not several, maybe there'll be hundreds and hundreds of cases where under these circumstances we file. I've never seen any problem as long as these companies identify the office space separately for them in that sharing suite.
So Santosh, the next question is to you. At the time of registration, there is one address and they change the address. So Santosh, can you tell that, is that a possibility that they can change the address after the registration?
Yes, they definitely can change the address. As long as you are able to prove that it's the same entity that has filed the registration, then you should be fine.
What if there is a corporate change? After the registration, the assets got bought over by a different company. So the new company is a successor in interest. Can it also be done?
Yes. In those cases also it can be done. You just have to show that it's the same, that the entity was bought by another company, and they are taking all the liability for those petitions, and then that should be sufficient. Yeah.
Okay. So many people file in-house product with H1s with the in-house product development, right? Is there a need for a specific or to show the ability to pay for this in-house development product? So if a person has filed an H1, so do they have to have that amount in the bank to pay their salary? That question we get always all the time.
Yes. So in case if they don't have sufficient funds to show that they have the ability to pay all the individuals for a particular period of time, they at least need to have documentation to show that they have enough support from the investors or somebody, or if not, they have to provide a business plan as to how they're going to procure this amount to pay for the employees.
Thank you. Yes, brief, very brief thing.
Thank you, son. It's just a small point. As you said, the issue comes with the in-house project is whether there is a bona fide job offer exists for the individual when they're using in-house project. So they want to see the viability of the in-house project. Why do they need an H1-B worker with an employer paying $100,000? But H1-B regulations clearly says that USCIS has no authority to test the ability to pay of the employers. There are so many case laws on that. We can actually defend that. That's why whenever USCIS asks about the ability to pay for the H1-B workers, we say that it is not required. Employer is not required to show ability to pay for the H1-B employee. But however, if it comes to in-house project, as Santosh said, to show the bona fide nature of the job, it's important to show the financial wherewithal of the company that they have the ability to develop this project. They have the financial sources to have this project come into execution or into fruition. That is why we need to have some kind of a financial stability.
Thank you, Bhanu. So we'll wind up this with the last question, so starting with Santosh. What is your suggestion for the CAP, the registration? What are the common errors or anything you want to add to that?
So make sure, you whoever, whether it's the attorney or you, if you're doing it by yourself, make sure you enter all the data correctly at the time of submitting the registrations. And also make sure there are no double registrations that are submitted inadvertently. And as I mentioned earlier, you need to get an offer letter issued to the employee and then make sure they sign the offer letter accepting it before you submit the registration. And also, if a person, before you submit somebody's registration under Master's CAP, make sure they actually they meet the graduation requirements before June 30th.
Thank you. Anything, Prashanthi, you want to add to that?
Just quickly about the commercial space and having a home office, just one point to keep in mind is the USCIS wants to make sure that the companies are following all the laws of the land, and they are zoning laws. So just something to keep in mind if you are operating an office out of a residential location, that's something that might come into question.
Gunjan, you want to add something?
Just about the do's and don'ts of registration. We have a lot of employers who do handle the process of electronic registration themselves. So I always recommend, do print the copies of the passports and the degree copies, keep them by your side when you're filling, in that information. Check, recheck before you click on that submit button, because once submitted, you can't edit the registration. The only way to edit it is then to withdraw it and then, refile. Use that duplicate feature on that electronic registration system which USCIS provides, where you can quickly run a check to make sure that you've not made, 2 or 3 submissions, multiple registrations for the same individual. Otherwise, USCIS will void all of them. Thanks.
Thank you, Gunjan. Bhanu, you want to have a final word?
I tend to agree with all my colleagues over here. And do's and don'ts is this. Just one more thing which I would like to add is, ensure that you have some kind of a system where you can check mistakenly filing multiple registration for the same employee from your company. That means duplicate registration for your employee. Have some kind of a checks, some kind of a system in the office that you verify the information, what you're submitting about your employee, whether you already submitted that information to the USCIS system or not. Just do the search, what you've submitted, you will know that. Or just keep one Excel sheet for whom you have submitted, maintained by date, what you submitted and everything. In that way, you'll have a checks and balances whether you mistakenly going to submit the duplicate registration or not. We follow this in our office. It has been very successful for us. And we're just advising you all, if you're all doing registrations by yourself.
Thank you. One thing I want to add to that is don't wait for the last minute. That's one thing which we always see. There are a lot of things that can go wrong if you wait to the last minute. One thing is there could be technical glitches. Last year, we had a situation where we submitted 30 registrations. That was close to 12 o'clock, and everything disappeared. And the decision we had to make, it should be, again, resubmitted, that 30 numbers. If we had done that, the next day, everything came up, all the 30. If we had done that, it would have been rejected for duplicate registration. So there are a lot of ways it can go wrong, so don't wait for the last minute.
One more thing, credit card limit, very important. If you're registering yourself, there's a credit card charge limit per day for the registration. Last year, it was $29,000 for an employer to submit on a single day. The maximum limit is $29,000. That means if you register, that means it's basically it's 2,900 registrations you can submit per day maximum. That was the limit, because if you submit anything more than that, the credit card will be declined, and accordingly the registrations become invalidated. This year, I think that has been increased to 36,000 or 34,000. 39,000, I'm sorry. Thank you, Gunjan, I appreciate that. 39,000, so keep that in. You cannot submit more than 3,900 registrations in a day. Very, very important.
And I'm sure there would be companies that will do more than
More
that.
than
And
that,
they
yes.
will. But to add to the credit card, when you're doing multiple registrations as small batches, what could happen is you're doing like $50 multiple times. The banks would treat them as some fraudulent transaction. So it is better you call the bank and inform them that there would be a multiple transaction that would happen with the same numbers. And if now towards the last day, if the submission will go through, but after 2 days the banks will reject that. If the banks reject it, your registrations are all going to be get
That's
denied, and you will lose the chance. So
That's a great point. That's
so
a great
better
point, Thomas.
Call the bank before you do the registration and
Yeah.
tell them that these are not fraudulent transactions.
That's a great point.
Thank you very much. We can keep talking about this for the whole night, but thank you and really appreciate for